In an attempt to smite the incoming Congress, Adams appointed 16 judges and 42 justices of the peace, including William Marbury. These appointees were known as the infamous Midnight Judges. Adams was allowed to do this by the new Judiciary Act of 1801. The court rendered a unanimous decision 4-0 on February 24, 1803. Chief Justice Marshall wrote the opinion of the court. Marshall presented the case as raising three distinct questions. Did Marbury have the right to petition? Do the laws of the country give Marbury a legal remedy? Is asking the Supreme Court for a writ of mandamus the correct legal remedy? Ladies and gentlemen, we present you Marbury v. Madison.
All rise. The Honorable Chief Justice Marshall presiding. Five U.S. 137, Marbury v. Madison. This court is now in session.
Marbury v. Madison is a landmark case in the United States law and the basis for the exercise of judicial review of federal statutes by the U.S. Constitution of the United States under Article 3 of the United States Constitution. The case resulted from a petition of the court by William Marbury, who had been appointed as Chief Justice in the District of Columbia by President John Adams shortly before leaving office, but whose commission was not delivered as required by John Marshall, Adams' Secretary of State. When Thomas Jefferson assumed office, he ordered the new Secretary of State, James Madison, to withhold Marbury and several other men's commissions. Marbury and three others petitioned the court to force Madison to deliver the commission to Marbury. The case was ultimately unsuccessful for Marbury, who never became Justice of the Peace in the District of Columbia.
I call William Marbury to the stand.
Who, me? Well, you see, what happened was, I was just sitting there, and then Mr. Adams called me up and he said, well, sir, I'd like to offer you a job. And I said, all right, that sounds great. And then once I took the job, they were like, hell no, we ain't giving you no money. And I was like, please, sir, may I have another?
Objection! Relevance! I'll allow it.
But that no gooder ding dang dong ding dang ding dang diggity dong ding dang periwinkle ding danger wouldn't give me my money. So I've come here today to ask you, Mr. Judge, for my money. Please, sir, please. Well, I guess now I've just got to call Mr. James Madison to the stand.
I was just doing what I thought was right. And Mr. Jefferson told me that I shouldn't give them their pay because they were doing midnight rendezvous and I don't know. Anyways, I was just doing what I thought was right. So, in my opinion, you deserve no pay, mister, because I was just doing my job. Writ of mandamus.
Thank you. Has the jury reached their verdict? Thank you. The jury has reached a verdict. In the case of Marbury v. Madison, the court rules in favor of James Madison.
Hey! How'd you do that?
Well, with the newly established judicial review. If it be said that the legislative body are themselves the constitutional judges of their own powers, and that the Constitution they put upon them is conclusive upon the other departments, it may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provisions in the Constitution. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature, in order, among other things, to keep the latter within the limits assigned to their authority. A constitution is, in fact, and must be regarded. Must be regarded by the judges as the meaning of any particular act proceeding from the legislative body. Constitution ought to be referred to the statute, the intention of the people, to the intention of their agents, the intention of their agents.
Yeah.